My name is Anna Escobar. I'm the General Sessions Judge for Division 3, and I'm one of 3 judges who hear domestic violence cases 8 months out of the year. I also preside over a treatment court called Cherished Hearts, which is for human trafficking survivors who are involved in the criminal justice system. I've grown up in Nashville my entire life, and it is a pleasure for me to serve the citizens of Davidson County. So an order of protection is a civil order that asks a person to stay away from you for a year. During that year, they can't call you, write you, text you, come by your house, come by your place of work. And when I'm kind of giving the spiel, I also say don't post things on social media. Even if you don't put the person's name on it, don't put a social media post that's directed at the other person. Also, you shouldn't be contacting people, third parties, such as family members or friends, to deliver messages to the person with the order of protection. Because if you do, then it becomes criminal. And each text message, each voicemail, each phone call can carry 11 months and 29 days in jail. Also, during the order of protection time, the person who has been given the order of protection cannot own a gun or possess a gun for a year. They are supposed to give the gun to someone who can legally hold it for that year, and then they can get it back. It gets very difficult for us to enforce, as judges, the orders of protection if there are text messages going back and forth. Because people are very brazen and can say anything on social media because they're not saying it to the other person's face. And then other people start chiming in, and that can really flare up tempers and really cause some violence between parties. It is absolutely awful. I've seen people shot over a social media post. Unfortunately, they are violated. We have plenty of violations that are pending in court. It can be as simple as just a phone call and the other person never speaks, but that phone number called the person with the order of protection. That's a violation. It could be as horrible as somebody coming and committing another crime. Now, if you commit a crime such as a domestic assault while you have an order of protection, the law does allow for the crime to be a higher level. If in the state of Tennessee, for you to qualify under our domestic violence system, it has to be a family member who's the perpetrator, an intimate partner, or a roommate. And so then if you have that relationship with that person and they commit any crime, it can be vandalism, theft, assault, what you traditionally think of, aggravated assault, anything while you have that relationship becomes a domestic violence crime. And so when you're in the domestic violence system, you do have a victim witness coordinator that works with the DA's office to coordinate what you will expect and where you need to go and what you need to do once you get to court. Now, if you're on a non-domestic violence docket, it is true that you will not have, more than likely, a victim witness coordinator who can help you on a non-violent crime. Well, in Nashville, we are so lucky that the Gene Crow Advocacy Center exists. And that is a center that is located in our courthouse. They've decorated it in a very trauma-informed way. It looks like someone's living room. So you're able to check in there and wait for your turn, for your case to be called while you're there. They have snacks, a bathroom, reading material. If you need to Google something in a safe environment, they have computers. So you were able to wait there, because we have found, in the past that while victims were waiting for court, the perpetrator, the defendant, the defendant's family oftentimes were threatening victims, maybe not outright threats, but hostile looks, hostile body language, and that became very intimidating for victims. And once their case is called, somebody from the Advocacy Center will bring them up to the courtroom so the victim doesn't have to guess about where to go, what floor, that kind of thing. On the morning of court, typically the district attorneys will ask you to arrive about 30 minutes early. They'll meet with you, kind of check in with you to see how things are going, if things have changed. Then the DAs will come to court, the judge will call the docket, and at that point it's just to determine if the defendant is in court and whether they have an attorney. Then the judge will take about an hour break so the district attorney and the defense attorneys can speak about the cases, and if the district attorney needs to speak to more witnesses or victims, they have that opportunity. And many cases are able to be resolved under a plea arrangement. Many times the goal for these plea arrangements is for the person, the defendant, the perpetrator, to get counseling. So they'd like for that person to go to the Batter's Intervention Program. If the person does not want to take the plea arrangement, then there's either a hearing or a trial. In General Sessions Court, we can only hear trials for misdemeanors, not felonies. So if the person is charged with a felony, then we have what is called a preliminary hearing. At that hearing, it's simply a hearing to determine whether there is probable cause. And that probable cause is a much lower legal standard than beyond a reasonable doubt, obviously. So it's very basic. They want to know, did this person probably do it, and was there a crime probably committed? So the prosecutor is aiming to establish identity of the defendant, where it occurred, what they call venue or jurisdiction, and then each crime has elements, and so the prosecutor is trying to put evidence into the record that would support that each element of the crime was committed by the defendant. And then at that point, the defense attorney would ask the witness or victim questions. Oftentimes the defense attorney is trying to get more details so that they can later on prepare a defense, or they're trying to determine the credibility of the witness. Sometimes the witness can get frustrated because they're asked the same question over and over again, and it's important for the witness to remember that they're doing their job. Sometimes they do that so they're trying to get a rise out of the person to see if the person has a bad temper. And so it's very important to, when you're testifying, to listen to the question and answer the question. It's actually very difficult to have a domestic violence case before a jury because many people are not educated about the cycles and the trauma that people go through when they're in a domestic violence relationship. It could take 1 to 2 years to get a jury trial on a domestic violence case in Davidson County, and that was pre-COVID. It is a big decision for the victim of domestic violence whether they want to have this as part of their life for 2 or 3 years. So it's really what is best for the victim. Whether you're there to testify about a sexual assault or a domestic violence case, it is very hard. It is very hard to go to court and accuse somebody that you love, and that was your intimate partner or your family member or your roommate. It is very difficult. But you have to remember that everyone in that room has their own problems, and they're there because they're in their own situation, and many times they're not listening to what's happening in the courtroom. And that everybody there that works there are professionals, and they are used to hearing that kind of subject matter. Any and all prosecutors just want the truth. And if you don't remember, it's okay to say, I don't remember. It is worse to exaggerate, to assume, to think, to testify to something you overheard, because the truth is really what matters. Oftentimes, prosecutors will prepare bullet points of the things that they know that witness can testify to and what material needs to be covered through their testimony. So there's never really a script, or you really can't give the wrong answer. As long as you're telling the truth and you have discussed with the prosecutor ahead of time what it is that you can offer in the testimony to prove the case, because each witness adds something to the bigger picture. If they don't come to court, a subpoena is actually a court order to come to court. So they could face contempt. They could be arrested as a material witness and brought into court, and may have to go to jail until they decide to testify. If the person comes to court and doesn't want to testify, there is a way that a prosecutor can prove that the person has now become a hostile witness. And instead of asking open-ended questions, non-leading questions, the prosecutor can ask very direct leading questions to get the information that they need. Most of the time they are open. When a victim is underage, a judge can consider closing the courtroom, but most of the times the courtroom is open to the public. If the media has filed their notice and they follow the procedures set forth by the courts, then, and if the judge gives permission, then they are able to come to court. It would be great if victims would take pictures of injuries, of damage. The police department will do that as well, but you know your property, you know your house. So taking pictures, documenting your injuries, especially with a bruise, you know, as the days go by, your bruise changes. It could get worse, it could get less. Also, compiling a list of the people that saw what happened, or that you told immediately after what happened, and making sure that they will come to court and help in the case. I think it's very important for judges to remember that for a victim and a defendant, this is the most important day of their life oftentimes, and it's oftentimes the worst day of their life, and especially in domestic violence court, having to come to testify against your loved one, and sometimes the embarrassment that you chose that loved one, and how did you let yourself be in this situation, is incredibly traumatic, and we all need to be aware that this is an important day.